Hello everyone, I'm Nazarat Fatima and you're watching LiveLaw. As you know, the abrogation of Article 370 has been challenged in the Supreme Court on various grounds. And in relation to the same, we have created a series of videos on the arguments made by senior advocates as well as the Solicitor General and the Attorney General appearing for union. To understand the case better, please watch the videos made previously. Today in this video, we'll discuss a few arguments made by the Solicitor General and the Attorney General in the Supreme Court with regard to the matter. To begin with, during the hearing in the matter pertaining to the abrogation of Article 370 in the Supreme Court, the CJI orally remarked that Article 35A created an exception under three areas, namely Article 16(1), which is equality of opportunity for employment under the state, erstwhile Article 19(1)(f), that is right to acquire immovable property, which is now provided under Article 300A, and Article 19(1)(e), which is right to reside and settle in any part of India. In this context, he said, and I quote, "Though Part 3 of the Constitution is applicable to J&K, when you introduce Article 35A, you virtually took away the fundamental rights and granted immunity to any challenge on the ground that it would deprive you of a fundamental right under Article 16. The power of judicial review was taken away." The Solicitor General, Mr. Tushar Mehta, appearing for the Union of India, agreed and pointed out that the year 1927 was set as the cut-off year to define permanent residence as per Article 35A. And this resulted in a situation where rights were denied to people living in the region for decades. The Solicitor General also highlighted that women lost rights on marrying a non-resident. He added, and I quote, "Something which is impugned here is a constitutional exercise of power which confers fundamental rights, applies the entire constitution, brings J&K people at par with other citizens. It applies all laws which are welfare legislations to J&K which were not applied earlier. I have the list with me. Till now, people were convinced by those who guide them that this is not a hindrance in your progress. It's a privilege you fight for. Your lordships have at least two major political parties defending Article 370, including Article 35A. Now the people have realized what they had lost." He added that due to the removal of Article 35A, investments have started coming to J&K, and due to policing being with the centre, tourism has also started in the region. Mr. Mehta pointed out that around 16 lakh tourists have visited J&K since the abrogation, and new hotels have been opened up in the region, providing employment to a large number of people. Meanwhile, the Attorney General for India pointed out that the Presidential Order of 1954, which introduced Article 35A, had the effect of creating a new article in the Constitution. He asked whether the power of the President under erstwhile Article 370 to apply the Indian Constitution with modifications and exceptions to J&K could be exercised to add an altogether new provision to the Constitution. While stating so, he also said, and I quote, "Article 35A is not a modification of Article 35, it's a creation of a new article." The Solicitor General said that various provisions of Indian Constitution remained inapplicable to J&K because of Article 370. He underlined the effects of Article 370 on the application of the Indian Constitution to J&K and argued that the certain provisions had a disparaged application to J&K. Let's take a look at the provisions. The first one being, the Constitution of India amended and inserted Article 21A to provide the right to education. However, this provision was never applied to J&K till 2019. The second one being, the 1976 amendment to the preamble of Indian Constitution was applied with modifications. Thus, the words secularism and socialism were never applied in J&K. Further, the word integrity was also not applied. The third one being, the directive principles of state policy were not made applicable. The fourth one being, reservations for tribal people was not applied in J&K till 2019. The references to scheduled tribes was removed from Article 15(4). The fifth one being, in Article 19, a sub-Article 7 was added by way of modification, which remained till 1979. As per this, the words reasonable restrictions were construed as meaning such restrictions as the appropriate legislature deems reasonable. In this context, the Solicitor General said, the citizens apply fundamental rights against the state, and now the legislature would decide what are the reasonable restrictions. Number 6, in the context of preventive detention, Articles 21 and 22 would not apply. That would be all for now. We'll be back with another video covering more arguments very soon. Meanwhile, if you find our content useful, please like and share the videos. Also, please subscribe to our channel and keep supporting us. Thank you for watching.